I assume that we will be reporting back to the legislature in some way in connection with SB 211, and my expectation would be that we would convey this in connection with that and in connection with the planning and execution of the staffing analysis that is still remaining out there as part of the SB 211 process.
And I apologize for the naivete of this question. I can't talk on 3 cups of coffee. But is there any sort of interaction prior to SB 211 in the reporting, just kind of as a heads up?
We can certainly do that. I take it you think that would be a good idea.
You know, I think dialogue and multiple access points are always a good idea.
So yes, I can see about getting that done and talking with legislative staff and letting them know about the reorganization and what we're trying to do.
Thank you.
I mean, certainly the infrastructure is there for that type of additional communication. I know that Ms. Leah and her staff are constantly in communication with ledge staff on many issues. So, you know, we'll just hate to do it, but add it to the list of the topics for discussion there. And I'm hoping that, as Trustee Shelby indicated, it's, you know, a sign of our continuing effort to partner with our stakeholders fully and openly. Okay. Yes.
You know, I just another issue. I know we're going to move on from this, but I'm tying this back into audit committee and when we were talking with Mr. Zuniga about just kind of brown bag. And I know that Arnie, about a year or so ago, talked about doing brown bags with the legislature. What a great opportunity to do a brown bag with legislative staff as it relates to what is transpiring in a discipline and the changes that have happened. And so I don't know where the brown bag piece resided, but hopefully in my comments today in terms of highlighting the fact that we talked about brown bag, that brown bag gets back into the mix somehow, so.
Okay.
Okay, thank you. Let's move on to 60-3, the report on the results of the client trust account bank reportable action pilot project. I've been looking forward to this report. Thank you, Mr. Cardone.
So I think I'm going to be joined by Ron P. And I hate to say it, but can we pull up the presentation? And I have no idea if this will work.
I will control. Just let me know.
Okay.
I see that Mr. P has joined us. Good afternoon, Ron. Welcome.
Good afternoon.
All right, so I'll lead us into this and explain where we are, and I think Ron will take over for most of the data slides. But if we can go to the first slide. So if you recall, in April of 2022, the state audit report came out and made several recommendations regarding both bank reportable actions and client trust account related cases. So first, there were a series of recommendations regarding to our handling of what are referred to as de minimis closures of bank reportable actions. And basically, these are closures. So a bank reportable action is a report from a bank that's required by statute whenever an insufficient funds transaction occurs in a client trust account. De minimis closures of bank reportable actions are closures of bank reportable actions that involve insufficient funds transactions of $50 or less. And so that's the terminology here. So a number of the recommendations were made, including that we stick to our policies and not use informal guidance. We've done that. That we revise our intake manual to disallow de minimis closures if the attorney has a pending or prior bank reportable action or a case alleging a client trust account violation. And as I've set out here what we've done to address that, and establish a monitoring system to ensure that we're complying with those policies, which we will now do now that the pilot project is over. We had advised the state auditor that the monitoring would be put in place after that. So those all relate to kind of the intake phase and closing bank reportable actions before they get to investigations as de minimis. If we can go to the next slide. Right. Nope, that was it. Sorry. There were also recommendations regarding investigations, and in particular, this recommendation was the primary one, that when investigating these types of cases, we require our staff to obtain both bank statements and the attorney's contemporaneous reconciliations with the client trust accounts and determine if the relevant transactions are appropriate. We were doing that in many cases, but not all. And originally, the State Bar objected based on resource needs. In June, we agreed to implement a pilot project to try this out, and that pilot project, in fact, began in August 1st of last year. We designated a pilot team to do this, which consisted of 3 attorneys, a supervising attorney, 4 investigators, 2 paralegals, and 2 program specialists to handle this. We were given an additional 12 FTE to support this program, and the program then operated from August 1st. It ceased operation the last week of June, because we have now made this permanent, as we'll explain later. And that then gets into the data analysis, and I will turn it over to Ron, who can discuss kind of, well, I guess I'll take this one, how cases were assigned. So basically, each week we would identify all of those cases that we're going to move to investigation of bank reportable actions and client trust account related cases. There would be a pool of those cases created. The pool would be a random selection, such that approximately 50%, with a cap of 20 per week, were sent to the pilot project to handle. The rest were handled by our ordinary trial teams using the ordinary procedures. The pilot team then applied the heightened investigative procedures recommended by the state auditor. And then the results of that have led to the data that Ron will talk about in detail, so I'll turn it over to Ron for the data analysis.
Waiting for the next slide.
So if we can go to the next slide.
So in my portion, I'll discuss how we pull the data, how we set up the design of the study, and then identify relevant outcomes to assess the impact of the program. But before going into detail of the method and data, I just want to highlight some overarching considerations about the study design and methodology. This study design, having a randomized assignment, is the key that allows us to look at the outcome and a lot of the other impact assessment in a very reliable and rigorous way. However, there are some limitations in our current assessment of the results. One is the limited amount of time in following up the results of the cases. In December last year, we took a first preliminary look at the outcome. At that time, it was determined that we don't have enough cases moving to disposition, so we don't have enough information to determine either the outcome or case processing time. So we recommended it at that point to extend the time up to at least March in order to have more cases that will allow us to look at the outcomes. So time limitation. The other part was well, it's random assignment, but it's only random assignment of the cases. There's a special team handling it, so it doesn't really meet the gold standard of double blind kind of a random assignment, where the team might be handling the cases differently, not or more than because the protocols are different. Individual staff assigned to the different teams are different. So we are also very careful trying to look at all the different factors to eliminate these kind of confounding factors. Another thing is the phased approach needs to be extended to more than the current assessment, because some of the cases will move on to kind of a recidivism tracking. Just that will allow us to answer the question that, given the impact that we're seeing now, at the end, to what extent it has a longer term impact on attorneys' misconduct behavior. So going into the overall design, starting from random assignment, as George mentioned, our random assignment process started in August. We have a staff getting the pool of cases every week and then running through a kind of a random assignment algorithm, assigned half the cases to each pilot group. And the selection criteria is that they are either bank RA or CTA cases. And we often just look at the profile of the cases in terms of demographics and other things to ensure that the random assignment actually achieve the equivalency or comparability of case characteristics in the two groups. About half the cases are assigned to each of the group. For attorneys with multiple cases, during the period, we also want to make sure that they belong or go to the same group so that for processing, it doesn't cause any unnecessary confusion. And we focused from the beginning, we designed the data collection trying to focus on a few major areas. One is to look at the overall background of these cases, taking a longer look about how bank RA and CTA cases tend to go through intake investigation in all of these outcome measures. The other is we look at the cases in both groups to examine the outcome, whether as they came out of the investigation stage or going into charging stage, or even within investigation stage, what are the different reasons of the closure? Those will give us a better sense about the impact. And also processing time, obviously, we always track the impact of any different kind of intervention. Now, workload analysis has to do with what I referred to the potential confounding effect. We want to make sure that whatever different outcomes that we saw is not because the workload assignments in the two comparison groups are different. So that's one of the things we followed up. Next, please. So this is already covered in what I just previously discussed. The focus of the analysis is to look at the time spent in intake and as some background information before the cases are assigned to the group, and the rate of the cases moving beyond intake. That has to do with what George earlier talked about, de minimis cases, how they are handled in the pilot program. And then to look at the case level data, we look at the proportion of cases moving beyond investigation stage or within investigation closure, the different outcomes. So here it shows the background of the cases before assigned to the program in either group. And in the bar chart that you can see for bank RA cases, before and after the start of the pilot program. Before the pilot program, about 80% of bank RA cases were closed in intake. And after the start of the pilot program, because the de minimis rules are changed, only 24% of the cases were closed in an intake. That led to a substantial increase of cases, bank RA cases moving on to investigation. And that is the major caseload going to the pilot program. For CTA cases, overall, it accounts for a smaller proportion of the overall program cases. And before and after, we didn't see any difference in the proportion of cases moving beyond intake. Next, please. And then we took another step just to look at the overall timeline for intake case processing. The trend line started to move upward in mid-2021, but the fluctuation of the timeline over the entire several years doesn't indicate that is the result of the pilot program. We'll be able to see greater impact in the investigation stage. Next. Before we look at the impact, we just spent a little more time trying to make sure the case type composition and other characteristics of the cases are comparable. So this is a comparison of the two different case types in the pilot versus non-pilot groups. You can see in the bar charts, the division of these two types are very close. So that ensure the case characteristics, at least in terms of the case type, are very comparable between the two groups. And then the following few slides showing similar comparisons, demonstrating that the case characteristics in many different areas are very comparable. And the first chart here is the firm size based on the data that we have available. Race and ethnicity of the attorneys are also comparable, or to the extent there are some differences, the differences are not statistically significant. Moving on to the next one. in addition to firm size, race, gender, age, all of these are very close between the two groups. So that is just the result and the beauty actually of random assignment, that allow us to focus only on things, measures that matter, so that there are no complicating factors. A case stage, this is based on the pilot versus non-pilot comparison in terms of how far they have gone up to this point and when we collected the data. So you can see clearly in the two bar charts, there are some cases in the pilot program going beyond the investigation stage. That is an indication of the cases being processed with different outcomes. And then we will follow up more. Next, please. With a few remaining minutes, I'll go through the few slides quickly. And we also look at, in addition to how far the cases went in terms of investigation and the subsequent stages, here is looking at the status in terms of open and closed. Closed cases, you can see 60% as opposed to 44%. Pilot program is moving faster. That is, in terms of the percentage, that is a clear indication. Next, please. Here is a more detailed look at why pilot cases are in the average or the proportion closed indicates that it's moving faster. It's because at two ends of the distribution of this chart, showing the shape of the amount of time it takes for cases to reaching final disposition, for the blue line, in the earlier phase of the distribution, you can see more cases closed earlier. And at the far end, to the right of the chart, you have fewer of those cases in the pilot program taking longer. So this is the result of condensing and moving the case disposition time in the pilot program closer and overall taking shorter time. Next, please. After looking at case time and then the phases that they moved on, for those closed in investigation, you can also see in this chart clear difference about the disposition of the cases in the pilot program. So 40 on the bar chart, the upper one, 40 and 30% in the pilot program, they received either resource letter or warning letter, as opposed to a much smaller percentage in the non-pilot program. Next, please. And bank subpoena is what we identified as the mechanism that leads to different case outcomes. You can see in the pilot program, 80% of the cases where they issued the subpoena compared to 28%. Next, please. And we also try to look at the outcomes in terms of characteristics of the respondent. Here, largely, whether looking at firm size or some other characteristics in the next few slides, there are some differences, but overall, we found the sample size is relatively small. That at this point doesn't allow us to say to what extent that there is a significant difference in the composition of the firm size with different case outcomes. Next, please. This is comparison of the outcome by race and ethnicity of the respondents, fairly comparable largely because the overall sample size is also very small. Next. Gender, you see similar picture. Here you have a larger difference, and the larger difference with the smaller sample size indicates that there is some real difference between gender in terms of the outcome of the cases. Next. And here is one of the things that I mentioned earlier, trying to isolate the factors in how cases are processed that might have contributed to the different outcome. And maybe one of the things is whether pilot staff has a lower caseload compared to non-pilot cases. Looking at the caseload trend over a longer period, there are ups and downs, but then the overall comparison shows that the caseload are fairly comparable. So that is ruled out as a factor, so that we can safely say it is the protocol of the cases being processed in the pilot program that led to the different outcomes that we have seen. Next, please. So overall summary, caseload process, we can see that the proportion of bank RA cases moving beyond intake increased from the original 20 to 80%, and proportion of CTA cases remained unchanged. And program impact, we saw clearly, pilot program led to more of the issuance of warning letter or resource letter, and case processing time also seen some improvement. Staff workload is not a contributing factor to what we saw in the program impact. Next. So this is going back to George, talking about the next steps, and he already alluded to earlier.
Yeah, so basically what that's showing based on the data that the cases are moving faster in the pilot team, and the outcomes seem to be more in line with what we would want. We're making this permanent. We've set up a team, the details of which are outlined here, that will now be handling the vast majority of our bank reportable actions and client trust account related cases that move to investigation using the methodology suggested by the state auditor. So that is in place now as of July 1st. The team you'll see is larger in size because they're going to be handling the vast majority of those cases. And with that, I think we're done, and I'll open it up for questions.
Thank you, George. Thank you, Ron. Any questions on the presentation? Trustee Sewell.
I believe we've talked about this before, but you know, George, I'm not sure what success is in this category of sort of investigation, in this category of cases. Is it the recovery of the funds? Is it the can you just talk to me about that?
Sure. So it's the eternal problem in terms of assessing what is the successful outcome, which is going to depend on the facts. But generally, we would expect that some percentage of the complaints that come in that allege that there has been a violation of a client trust account related rule. So for example, that someone has failed to properly account for funds in their client trust account. Or in the worst case, that they've misappropriated those funds or stolen those funds. We would expect some percentage of those cases to result in action, and ultimately, for some number of those cases, disciplinary action. The state auditor's report suggested that there had been cases that had been closed that shouldn't have been closed because of a defect in the investigative procedures. So assuming that that's the case and that that was the matter, we would expect as we implement the pilot project to see some increase in the number of cases involving those types of offenses that move forward to some disciplinary resolution, or at the least the issuance of warning letters to reflect that there's been a issue identified and that we've taken action to address it. So success is largely what we saw in the pilot project, which is, at least based on the small sample we have that have gone to outcome, the outcome has been driven more. In other words, there are more warning letters and more cases moved forward for disciplinary charges. So that's in my view, that's a successful outcome. The second outcome is, are we able to use the heightened investigative procedures without affecting the time that it takes to move those cases through? And again, the data suggests that we are.
Thank you. Any other questions or comments on the report? Thank you, gentlemen. I'm going to exercise a little bit of discretion of the chair here to move our agenda around a little bit. Items 701 and 702 are financial for the board. I think given that we've got some guests here on other items later in the agenda, we'll move those down probably towards the end of our board agenda. This is us back meeting as the Board of Trustees and not in our capacity as a Regulation and Discipline Committee. So we are now in item 700. I will note for the record that I've also asked that item 60-4 come back at our September meeting. I'm told that there's no urgency to that report, simply a status, and our general counsel was kind enough to accommodate me there. So thank you, Ms. Dovtian. That will bring us to item 704, which is the update regarding State Bar rule related to the Commission on Judicial Nominees Evaluation, in-person candidate interviews, which is Rule 7.52. An update on the assignment of judicial nominee evaluation commissioners, Rule 7.40, and recommendations for additional 2023 funding. We did receive some public comment on this already. I see that we have the chair of Jenny in the room with us, Mr. Palmer. Welcome, sir. If you would please approach the podium. I believe that you and Ms. Grammy are designated to present on this item.
Yeah.
Good
I
afternoon
can't
and
see,
welcome.
sorry,
Ms.
I
Grammy,
can't see
welcome.
if Justin's at the table.
I don't know if Ms. Wilson's kicking us off or Ms. Grammy. Okay,
I-
Bridget.
I can go ahead. Yes, thank you. Thanks to everyone. I'll be as brief as possible. I'm very happy to be presenting this item with the chair, Mr. Palmer, here today of Jenny. As you might remember from your last meeting, we've been discussing some proposed amendments to the Jenny rules having to do with in-person, particularly in-person candidate interviews, and whether we can continue the practice of doing Zoom judicial candidate interviews. We've received a lot of public comments, as you'll recall, and the board voted to table the discussion on that particular Rule 7.52 at the last meeting. In the interim, Mr. Palmer and the Vice Chair, Chaya Malik, and I and the Jenny staff have been meeting very regularly and very collaboratively. I'm very appreciative to both of them, particularly in light of all of their work that they're doing on Jenny on top of all of this. And I'm happy to say that we've come up with a compromise on these rules right now, and staff is recommending, as you'll see in the item in more detail, that rather than move forward, I'm recommending that we move forward with adopting amendments to the proposed rules. We would instead staff will withdraw our request and instead have a task force of just a small number of members selected by Jenny leadership and a representative from the State Bar Board of Trustees to take a comprehensive look at all of the Jenny rules as they relate to operations and come back to the board in November with more comprehensive recommendations on the best way to move forward. As you'll also see in the item, we've been talking a lot about the budgetary constraints that we're experiencing, and particularly the 2023 budget that cut the hotel nights from 2 nights to 1 night for the Jenny meetings. Again, we've been working very closely with Jenny leadership, and staff is recommending that the board go ahead and authorize an augmentation to the budget that would allow them to go back to the two hotel nights, because it really has significantly impacted the operations of the Jenny Commission. I'm sure Mr. Palmer can elaborate on that. And then the last item that you'll see is a proposed amendment, or it was an amendment that the bar adopted last year at the last July meeting at 7.40, which was intended to address a potential issue having to do with the Jenny Commission's ability to consider appellate candidates and the requirement that a public member be on each investigating team. There was a concern from the governor's office that it might be holding the commission up from investigating more appellate members. And so we went ahead and adopted the amendment that just said, it would be to the extent practicable. However, we have been able to just continue the regular practice of we've always had a public member on each of these investigating teams for Jenny for all of the appellate court and Supreme Court candidates. So we haven't in practice needed it. The board asked us to come back at the May meeting of 2023 to just report on how that rule was being implemented. And due to an inadvertent omission, we forgot to put it on the agenda for the May meeting. So we're bringing it back to you now to update you. And staff's recommendation is that we just include a revision of rule, or a consideration of Rule 7.40 as part of the entire comprehensive package that we'll be looking at with the task force for the Jenny rules. So that's my very brief overview. I just wanted to turn it over to Mr. Palmer to see if he had any additional comments. And I know Ms. Wilson too has been very helpful in helping us to reach these agreements.
Ditto. I'm a man of limited words. In my brief time before you, if I can exercise personal privilege, I wanted to first thank the board generally for your thoughts and your consideration of this item. The temperature of the room is a bit changed since we were last here, and I know Ms. Peñalosa is in the back. Our commission doesn't show up when we're just angry, and we have a lot to say. We also show up when things are going well, and we wanted to express our gratitude, both me personally and on behalf of the commission. So thank you for this consideration and this opportunity to work with Jenny's staff. If I could also thank Leah and Bridget directly for their patience in this entire ordeal, for the many conversations that we've had. I have a philosophy in my personal life that there aren't really winners and losers. I think there's mutual agreement and understanding. And I think the dialogue that we've been able to cultivate in these last few months really reflect that. And I'm hopeful and I'm optimistic that in the next few months, as we consider these changes or ideas for change, that we will endeavor to present something jointly to you for you to consider that's based on research, that's not based on anecdote, and that are rules and ways to improve the efficiency if necessary. That's the second thing I wanted to say. The third thing I wanted to say was my commission, I and others will continue our efforts to educate you all as a board about what Jenny does, why it's important, not only to the judiciary, but also for the communities that comprise California, and also for generations to come. Judges they occupy a special place and a powerful position in our communities. They have the opportunity to impact little boys and girls, to inspire them to become judges, but also make really real decisions that can sway people. And so that's why we're passionate about this work, and we'll continue those research efforts. So with that, I'll yield the balance of my time, Mr. Chair, and I'm happy to entertain any questions that the board has.
Thank you, Mr. Palmer. Thank you, Ms. Grammy. Any questions from the board for either of our presenters today? I saw two hands. Trustee Buenaventura.
I love what you said about how the temperature has changed and how this is a feel-good moment, I think, for everybody, because what has happened is that dialogue happened, an attempt to gain insight into both sides occurred, and I think out of that comes a really positive outcome. And this task force, I think, is a remarkable thing to move forward to. I think the component of educating us into knowing a little bit more about what you do and what you need to continue to do your job is important for us to understand. And I think this is the right step in getting to that place. And so I appreciate the fact that the temperature has changed. I appreciate the dialogue, the cooperation, the trying to build consensus. And this is too important a task to rush. And I so appreciate us taking the time and slowing this down a bit and moving forward. So thank you, Mr. Chair.
Thank you, Ray. Vice Chair Stallings.
Thank you, Mr. Chair. I just wanted to echo Trustee Buenaventura's comments, and then also just what staff and Mr. Palmer has iterated here to this body. I think that the more communication that we have, the more power we have going forward. And one of the things that was, I think, really powerful with the meetings that individual trustees had with members of the legislative bodies, particularly the Assembly and Judiciary, or Assembly and Senate Judiciary committees, was that we really could educate them on the needs of line staff. And I would just invite Jenny members to also engage in that sort of dialogue with legislators that you know. And really, I think just that continuing education is going to build this groundswell effort. And really just hopeful that we can continue to work, move forward. Really want to commend Leah and Bridget and Justin, you guys getting together. And I really look forward to seeing what happens with the task force. So fortunately, it doesn't seem like it's going to be a long meeting task force, but really excited to see the proposals that come out of that.
In truth, Leah did all the work. I just said yes. But
We know that she does, and so as long as we can call her forward.
I was just going to say, I'm not surprised by that. Trustee Shelby, please.
I just wanted to convey my appreciation and echo the sentiments that were made by my colleagues and my vice, Mr. Stallings, who I serve with from an appointments liaison standpoint. The one thing that I would add, if I had the opportunity to add an addition, and I appreciated how you talked about education as we went out and did outreach to legislative offices. We talked about the dollar and the $107 fee increase that we talked about with legislative staff as we work to educate on the need of being fully funded for this organization. And I say that because I think it's important for us to articulate that. We received those numbers from our executive director, and we went out and had these meetings, and within that, Jenny was identified as a dollar of the 107. And I know, Mr. Palmer, you've been involved in meetings that we have had with the governor's office. And so in the education piece, as we become more educated on the hundreds of hours that Jenny commissioners volunteer as it relates to their time, just the ability to educate, once again, not to be redundant, going back to this brown bag, but really being able to educate the legislative staff on the understanding of funding that is needed, and also the utilization of Jenny commissioners as we reach out, because I think there's no better voice than the voice of the volunteers who do the really challenging work, and the work that you all are doing on behalf of vetting judicial nominees for the governor's office is an incredible thing. So I want to say thank you to Ms. Wilson. I want to say thank you to Ms. Grammy. I want to say thank you to Mr. Palmer and the balance of the Jenny Commission for working together. And I wanted to make a quick note. As Brandon and I were working on the appointments, there was a something that arose in one of the sub-entities, and one of the things that we offered collectively was going back and having staff and the sub-entity work together, and this is a great example of what transpires when we do that, because we're all here to support the function of the State Bar as it relates to transparency, accountability, and oversight. So thank you to you all.
Thank you, Trustee Shelby. Trustee Sowell, and then Trustee Cisneros, were you still in the queue? So,
Just very quickly, I mean, I too will just echo all the sentiments that have been articulated already, and just say, sort of thank all involved and sort of short circuit that. I do have one question, and that is just from a timing standpoint. I'm just trying to connect some dots here. And the work that Trustee Shelby and Trustee Stallings and Louisa talked about a little bit earlier today about the appointments, and the fact that the Jenny Commission now is going to have a higher percentage of public members. When does that kick in?
I can address that. Go ahead.
The next class,
next year.
yep. Trustee Cisneros, please.
Here to echo everyone's good sentiments and congratulate everybody on the great success and move the motion.
Motion has been made. We'll have the resolution presented. As that's coming up, I will, I'm going to add to the echoes and just exercise my own point of personal privilege, just to say that earlier today in our consent calendar, the board appointed Chaya Malik as the incoming chair of Jenny and Lorena Peñalosa as the vice chair. I was very pleased to learn that Ms. Peñalosa was involved with Jenny when I learned that at our last meeting. She and I are classmates from Hastings, graduated the same year together. I may be mistaken, but I think she actually babysat my older son at certain points when I was studying or trying to catch a nice night out with my wife of 29 years. So Lorena, thank you for your service. Thank you for being an Inland Empire presence here at the State Bar. Lorena is campus counsel at UC Riverside. Certainly happy to see you. Thank you. Is there a second on the motion, please?
Second.
Whoa, I think Brandon got that one. Motion by Cisneros, second by Stallings. If there's no further debate, can we have the vote, please?
Broughton, not present. Buenaventura.
Aye.
Chen. Trustee Chen had to step away. Cisneros.
Aye.
Good, not present. Knoll. Trustee Knoll.
Sorry, mute. Aye.
Thank you. Shelby,
Aye.
Soel,
Aye.
Stallings,
Aye.
Tony,
Enthusiastic aye.
Trejo,
Aye.
Duran.
Aye.
9 ayes, 0 nays, motion carries.
Thank you, Madam Secretary. Thank you all. Truly good work.
May I also say that I think it should be well established at this point that I'm all in. So if you need help on the legislative side and you want to utilize my efforts, limited as they may be, please call me. My cell phone is, Leah has it. I'll let you guys get back to work. Thank you.
Thank you, Justin. And we will take you up on that, I promise. Okay, that is going to move us to item 705. I see that Justice Brian Curry has joined us. So if you are ready, Mr. Justice, we will call up item 705. I think that you are presenting this jointly with Program Director Erica Doherty. We will wait for her to join us remotely, I believe. Okay. And Justice, if you would take a seat at the podium, we look forward to discussing this long-awaited action. Certainly a lot of work that has gone into this, which we will hear some details on. From Ms. Doherty, I don't know who is kicking us off.
I'm happy to get started, and I apologize to Justice Curry. I think he is under the impression that I will be presenting, but I would let him go ahead and make some comments first if he would like to.
Put you on the spot, Justice. I apologize.
Well, yeah, I do have it loaded onto my computer somewhere. Hi, I'm Presiding Justice Brian Curry from the Second District Court of Appeal, Division 4. Delighted to be here. I'm also the chair of the California Civility Task Force. These proposals arise out of work that we've been doing for the past several years, trying to get improved civility in the profession, both to make it a nicer place to work, but also because it's our view that a lot of civility stems from implicit or explicit bias. We don't have any real data on that, but by chatting with people in the profession over the last 30 years, it's clear to me that women, lawyers of color, young lawyers are on the receiving end of incivility far more than they are on the dishing out side. So we feel that having 3 new things in place: mandatory education on civility, disciplinary rules that deal with incivility, and having lawyers take the oath of office, which after 2014 included a kind of aspirational civility portion that lawyers would strive to be civil. Most lawyers were admitted well before 2014. So this proposal would have lawyers, all lawyers, take that oath and renew it annually. That gives judges like me and my colleagues in the trial courts some additional ammunition to enforce civility. We're under an ethical obligation to ensure that the proceedings in our courts are done with dignity and professionalism and respect and civility. And we do that in a whole number of ways, hopefully by leading by example. And a 4th proposal of our commission was to increase judicial education about civility, because we are aware that there are members of our profession who have exhibited incivility, and we want to stop that. But we also want to educate the members of our profession on ways to go ahead and fulfill their ethical obligations, to make sure that the lawyers, not only the lawyers in front of them that they can see, but lawyers who are engaged in proceedings before the court, because a lot of incivility occurs, as many of you know, I'm sure, outside the view of the judicial officer, but in deposition rooms and nasty grams exchanged over discovery disputes and so forth and so on. So these proposals give us more tools as a profession to make it more welcoming to women, to lawyers of color, to young lawyers, and really everybody. Because when you think about it, our workplaces are very unusual. If you think about a courtroom, you might have a prosecutor who works for the county. You might have a deputy public defender who works for a different agency of the county. You might have some private lawyers who work for themselves or a law firm. You have a court reporter, hopefully, less and less, but a court reporter, if you can find one, who works for an agency or him or herself. You have the clerks of the court who work for the court system, and the judge. Everybody basically works for somebody else. And so unlike most workplaces where if there's a problem, you can go to HR or the common boss to sort things out, there isn't such a thing in our workplace. And so we're hoping that these tools will help us regulate incivility, promote civility, and make our profession more enjoyable, more rewarding for lawyers who already are under an enormous amount of stress, subject to substance abuse, all sorts of things that I know you're very well aware of. So hopefully this will be just one thing that goes to make it a better place for us all to work. And thank you very much for all of your attention to this.
Thank you, Justice Curry. Erica, please.
Sure, and I don't have any slides to share today, and I'll just be very brief, and just Justice Curry obviously just gave you all the reasons for the importance of these changes, and I'll just talk very briefly about what the changes are in a bit more detail. So as you're aware, there were basically two sets of changes that I'll be talking about, and then proposed changes to the MCLE rules will be addressed momentarily. But the first change is to the attorney civility oath. And we're requiring all licensees to complete that oath one time, and then to affirm their commitment to it on a recurring basis. That would apply to all licensees, as well as certain attorneys that are authorized to practice in California through certain rules of court. Those changes went through 2 public comment periods. The most recent public comment period, we received 31 comments that took a position, the majority of which were in favor of those changes. In addition to that, there is a proposed new State Bar Rule 2.3, that would essentially implement the changes to California Rule of Court 9.7. Staff is requesting approval of those changes. 9.7 would have to go to the California Supreme Court for adoption. And as you'll see in the resolutions, we're requesting adoption of Rule 2.3, but essentially only if Rule 9.7 is adopted by the California Supreme Court without significant modifications. Turning to the rules of professional conduct, there are 3 rules that are being considered with amendments. Rule 1.2, Rule 8.4, and those are proposed comment amendments to both of those rules, and then a new standalone rule, which is Rule of Professional Conduct 8.4.2. All 3 of those also went out for a second public comment period. The majority of the comments were in favor of the proposed changes. I'm happy to describe, the proponent positions and the opponent positions in a bit more detail if you'd like. But essentially, in sum, based on those public comments, staff is seeking approval of the changes to the rules of professional conduct. And again, those would also require California Supreme Court approval. So happy to answer any additional questions you may have. I know this was brief, but I think Justice Curry really said a lot.
No, to the extent it was brief, I think it was still comprehensive. And certainly the board has followed along as the task force has done their work with great interest. I've really enjoyed meeting and interacting with Justice Curry. I admire the work that you've done with Vice Chair Stallings and Ms. Rosing from San Diego, and indeed the entire task force. Let me just pause here to ask whether there are any questions for either Justice Curry or Ms. Doherty, and if there are not, we will take the proposed actions in 3 separate steps, because there are 3 separate rules that we're going to vote to move on, or at least consider. How's that? Any questions, comments? Trustee Shelby.
I don't have any questions, but Justice Curry and Vice Chair Stallings and Ms. Doherty, I remember vividly having this conversation and having the opportunity to place the motion put the motion in play. And so, and what really struck me, and I'm a public member, but what really struck me was how passionately my colleague Highland Chin talked about civility in this profession. And I don't know if she is with us. And so I just want to thank her because she really helps to put into context the importance of moving this forward. And so with that, I just want to say thank you to you and the task force and all your work, and very excited to move forward with these 3 different actions today.
Thank you, Ms. Shelby. I echo that sentiment as well. I believe Trustee Chen had to step out of the meeting, but we will convey those thoughts for sure. Madam Secretary, Mr. Hernandez, could we see the first motion, please? Thank you. So this is item 705, item 1. There's for the trustees review. Did I hear a motion from Ms. Shelby?
Most definitely.
Is there a second to that motion on item 1? Trustee Cisneros with a second. May we have the roll, please?
Broughton, not present. Buenaventura.
Aye.
Chen, not present. Cisneros.
Aye.
Good, not present. Noel.
Aye.
Shelby.
Aye.
Soel. Stallings.
Aye.
Tony.
Aye.
Trejo.
Aye.
Duran.
Aye.
9 ayes, 0 noes, motion carries.
Thank you, trustees. Rule 9.7 will move to the Supreme Court, and we will hope for swift action there. Item number 2 relates to Rule 2.3, a new rule. You see it there on the screen. If there are no questions, may I have a motion on Part 2, please? Trustee Cisneros with the motion.
Second.
Trustee Null with the second. Can we have the roll, please?
Broughton, not present. Buenaventura.
Aye.
Chen, not present. Cisneros.
Aye.
Good, not present. Noel.
Aye.
Shelby.
Aye.
Soel.
Aye.
Stallings.
Aye.
Tony.
Aye.
Trejo.
Aye.
Duran.
Aye.
9 ayes, 0 noes, motion carries.
Thank you. Part 3 is there on the screen. Amendments to Rules 1.2 and 8.4 of the California Rules of Professional Conduct and the associated activity after that. Again, may we have a motion?
So moved.
Motion by Trustee Cisneros, second by Noel. Can we have the roll call, please?
Broughton, not present. Buenaventura.
Aye.
Chen, not present. Cisneros.
Aye.
Good, not present. Noel.
Aye.
Shelby.
Aye.
Soel.
Aye.
Stallings.
Aye.
Tony.
Aye.
Trejo.
Aye.
Duran.
Aye.
9 ayes, 0 noes, motion carries.
Wonderful work, everyone. I'm going to hand the microphone to Vice Chair Stallings for a second.
All right, thank you, Mr. Chair. And just as a point of personal privilege, I want to, hopefully briefly, but not very briefly, because there are a lot of people involved, express my thanks to Justice Curry for the enormous amount of work that he put into this project. Little did I know in 2020 when I spoke with then Chair Alan Steinbrecher that this commission would take this long, but also expose me to such professional and community service oriented people. And Justice Curry has been an exemplary leader by chairing the commission, by working with Heather Rosing and myself on our various side projects. And really, we were able to benefit from the wealth of information, the wealth of knowledge of many current and former volunteers of the State Bar, judges who are intimately involved in educating other judges about tools that they have at their disposal to address civility. And I just wanted to go through and thank a couple of those individuals. First, Chair Steinbrecher for twisting my arm and getting me involved with Justice Curry. It was definitely a beautiful thing.
He may have twisted my arm also.
Alan's good at twisting arms, so I hope he's listening in. Pat Kelly, former president of the state bar, who really started this back in 2014, and I just view this as a further iteration of and a further evolution of this profession's march towards being as professional of an occupation as we can be. Want to thank our partners over at CLA, Jeremy Evans and Emilio Veronini, who provided tremendous support and really access to their members and their wealth of knowledge. Judge David Wolf from Kern County, who was my co-chair of our subcommittee, who is also working to improve civility in Kern County. We had many judges who worked on this, just to name a few, and I'm going to leave people out, and I apologize, but Judge Brian Walsh, Judge Rice, Judge Besworth, Judge Wiley, who even think tomorrow is going to be putting on a training for judges on how to deal with incivility. Neil Wertlieb, if you've ever tuned into COPRAC, you would recognize that name. Doug Silverstein, and then our staff, who has just been so integral. Carissa Andreessen was there at the very beginning, and she helped to navigate the rules aspect and really set us on the right course for something that could actually be put into effect. So Carissa, thank you for your work, and I hope you're listening. Randy DeFantorum, our recently retired employee, but he put in so much work, and then that mantle was carried on by Erica Doherty. So thank you. Heather Rosing, you were a pleasure to work with, and definitely remember our fun time down in San Diego working out some of these details. And then last but certainly not least, Justice Brian Curry, thank you for everything. So it is a privilege to walk these last 3 years with you. I'm sure you didn't want it to be 3 years, and it continues on a little bit longer, but thank you for the 3 years of patience.
If I may, thank you all very much for your support, for sticking with us during this time period, and for listening and gathering to the public comment that you received, and for all of your support, Chair Duran, Vice Chair Stallings, and all of you. Thank you so much. And we hope to move this through now. The Judicial Council, I spoke to the Chief Justice about this as recently as last week. She's looking forward to receiving the proposals. So thank you so much.
Thank you, everyone. Let us take a 6-minute break, and we'll reconvene at 5 o'clock, 5:02, to get through the rest of our public agenda. Just a very quick bathroom break. See, we are live. Good enough. Right on. Okay, we are live and recording. We are back in open session. It is 5:02. We're going to move on to item 706, which are the proposed amendments to the rules governing minimum continuing legal education, attorney-required activities, and rules for providers. This is a return from public comment and a request for approval. This is being presented by Program Manager Rahimi and Managing Attorney Ongidi. I think both of those folks are with us virtually. So welcome. Once you populate the screen, hello.
Hello, can you hear me okay?
We can hear you fine. It's good to see you both. Welcome back.
Great. I'll start us off and then I'll turn it over to Araya. So thank you for the opportunity to speak to you today. This item was initially before the board back in November 2022. Since that time, the item went out for public comment. We revised some of the rules based on the comment, and it went out for the second round of public comment in May of this year. Now, the majority of the comments overwhelmingly support these proposals. 57 comments, and of those comments, they were all agreeing, except for one that agreed if modified and one that took no position. So today what we are asking the board to approve the proposed amendments to the rules that would add 3 topic requirements to the required courses that licensees must complete as part of their existing 25 credit hours per 36-month compliance period. It would provide that mock trial, moot court activities, and similar activities would be eligible for MCLE credit, and it would add changes to the provider's rules, that would improve the administration of the MCLE program. So if they are adopted, the amendments would revise the required MCLE requirements to add 1 hour of civility, 1 hour of technology, and to change the competence requirement from 1 to 2 hours to allow for a second hour on attorney wellness. The other amendment would allow for up to 2 hours of participatory MCLE credit for coaching or scoring mock trial, moot court, or similar activities. And then additionally, we made a non-substantive change to Rule 2.72 C1 to delete the unintentional reference to the other subparagraphs that didn't exist in the rule. Now, finally, the proposed changes to the MCLE rules will allow for the improved program administration, and it will facilitate compliance with the requirements by the licensees and providers. So I'll turn it over to Araya to talk to you a little bit about the provider rule changes.
Thank you, Kathy. Good afternoon, members of the board. I also appreciate the opportunity to talk to you today. As Kathy mentioned, in addition to the proposed changes to the MCLE rules applicable to attorneys, staff also proposed changes to the MCLE provider rules. And these amendments were also circulated for public comment for initially a 90-day period. And then following the first round of public comments received, certain proposed amendments were withdrawn, whereas others were not substantively addressed and did not require further revisions. They were held over during the second public comment period to allow the board to consider the MCLE rules in their entirety for adoption. There were some rules, however, that required additional revisions in response to public comments received during the first round, which then resulted in staff requesting that the board approving a second 30-day public comment period. Comments received during the second round of public comment were generally favorable, with most commenters indicating an agreement or an opposition with respect to the provider rules as well. California Lawyers Association provided specific comments on Provider Rule 3.602, which is responsibilities of every provider. The CLA indicated that providers should not be required to indicate whether an activity is self-study on the record of attendance, since attendance verification is not required for self-study activities. Staff agrees with this comment and has revised the proposed amendment accordingly to clarify that providers are only required to take attendance at participatory activities. Staff also revised Rule 3.602C to clarify that electronic attendance records are only required for participatory activities. CLA also commented on the proposed amendments to Rule 3.602D
indicating that requiring providers to provide certificate of completion to self-study participants is not feasible since providers are not required to verify attendance at such activities. Staff does not recommend any changes in response to this comment, however, since there are various methods of providing the licensee with a certificate of completion, including via hyperlink, mail, and/or email. Although providers are not required to verify attendance, issuing certificates of completion for self-study activities benefits both participants and providers by simplifying tracking and reporting in the event that a licensee's MCLE compliance is audited, as well as increasing the credibility and transparency of self-study MCLE programs offered by providers. In conclusion, the proposed amendments to the provider rules represent a comprehensive effort to improve the effectiveness and efficiency of the MCLE program. These changes are expected to result in a more robust and effective MCLE program, benefiting licensees and providers if approved by the board. And that concludes our presentation, and we'd be happy to address any questions or concerns you may have.
Thank you for the concise yet comprehensive presentation. Trustees, any questions for either Ms. Ongidi or Ms. Rahimi? Trustee Sewell.
I appreciate the work that went into this and the report. I have a question about the participatory MCL credit, and in particular, or similar activities kind of definition. And what I'm about to throw out there, I don't know. I'm not a lawyer, so I've never taken the bar exam, and so I don't know whether or not there's a conflict here or not. But we have not sort of addressed the admissions fee item, and as well as other items that are related to some of our financial condition. But I am wondering whether or not if there are possibilities for lawyers that are doing the need the MCL e-credit under that definition of similar activities, whether or not helping to proctor or being involved in the bar exam administration some way is something that they'd be eligible to do in order to get credit.
That's a good question. I mean, we do, when we review the activities for MCLE credit, we do review them by case basis. So as long as the activity would have substantive legal education or legal content, it could be argued that it can be approved for participatory or even self-study activities. So to answer you in short, we would have to see the content. It would have to be structured. It would have to have an agenda. So it's a little bit hard to say if proctoring would suffice. We would have to see the program and the written materials. For participatory, written materials is also required. So, and we would have to see it before the activity is approved.
I think our next item is going to be an admissions fee proposal, and Donna could speak to the possibility of this further. I think there's a couple of issues, including under our current rules, lawyers cannot proctor bar exams, but also I think it would be a kind of a stretch to count that as educational credit, but I don't know. I think Donna could speak to that next time.
Go ahead.
All right, thank you, Mr. Chair. And I like where Arnie was going with this. I think he's going to propose that every meeting for the Board of Trustees qualifies as at least one MCLE hour, so I will support that for sure. But in all seriousness, so this really strikes close to home. My wife's been involved in mock trial as a coach. I volunteered with that, volunteered as a judge, as does she now. And to see these kids step into a courtroom, like a real courtroom, and put on a trial, know the evidence code, read through transcripts and have these transcripts memorized like the back of their hand, and know case law and be able to argue case law, that really speaks to their ability to stick with getting through college. And we're talking about at the high school level that I'm seeing them, and these kids are so good, and it just gives them this opportunity to stick with it through college, through law school, through sitting for the bar. And I'll tell you, coming from a rural community, we've seen individuals who have gone through mock trial and are now practicing lawyers in Kern County, and it's incredible to see. And so you want to talk about increasing diversity, you want to talk about increasing the chances that lawyers who grow up in a community stay in that community and speak to the very real issues, this is absolutely one of those proposals that speaks directly to that. So I'm in full support, and I'm happy to move the item if we're to that point.
It's a motion by Stallings. Is there a second? Trustee Cisneros has seconded it. Any other discussion? Seeing none, can we see the resolution, please? There we have it. Roll call, please.
Broughton, not present. Buenaventura.
Aye.
Chen, not present. Cisneros.
Aye.
Good, not present. Noel. Trustee Noel.
Sorry, aye.
Thank you. Shelby.
Aye.
Soel.
Aye.
Stallings.
Aye.
Tony.
Aye.
Trejo.
Aye.
Duran.
Aye.
9 ayes, 0 nays, motion carries.
Thank you, Madam Secretary. We're going to go back up the agenda now to item 703, as suggested by Ms. Wilson. This is the update on the admissions fees and bar exam administration cost reduction options. Not exactly as suggested by Ms. Wilson, but I knew it had to do with the bar exam. Donna Hershkowitz and Program Directors Audrey Ching and Amy Nunez will present. Welcome, everyone.
Good afternoon. There we go. I'm going to kick us off. Audrey, if you can share the PowerPoint. If you can put in the slide show mode. Perfect. Thank you very much, Audrey. Good afternoon. I apologize, this is not going to be as quick as the last couple of items. This is a tough item for 5 o'clock, but thank you for letting us present to you today. Why are we here? The purpose of today's presentation is to provide you a status update on an issue that the board has discussed a couple of times already, and that's the proposed increases to the admissions fees. Which are necessary to address a significant budget shortfall that we're facing in the Office of Admissions. The second item that we want to present to you is a preliminary discussion of cost reduction models for the bar exam to fill the remaining gap between the revenue and expenditures in the Office of Admissions for the programs and services that they provide. But before we launch into the PowerPoint, I just wanted to give us a little context. When I was reading the public comments that we'll talk about in a little bit, when I was reading through them, I realized that a little context setting might be helpful for our newest board members as well as for the listening public. So 2 very brief points for context setting. So first, the state bar, as most of the board members know, does not receive any state general fund monies. The state bar doesn't receive property taxes or income tax dollars or anything of the sort. The state bar only has the money that we receive from fees in order to support and perform our functions. In the Office of Admissions, this means fees related to the admissions process are what we have in order to support those functions. Fees to sit for the bar exam, to get your moral character determination, to accredit a law school. In other words, the fees pay for the staff to do the work, for the expenses to put on a bar exam, getting bar exam sites, paying for those proctors that you were just talking about, and grading the exams. To deliver those services, to have staff, we must collect fees, and the fees need to cover the costs since there's no other source for them. My second and final point for context setting before we move through the slides is, and I found myself, and I was talking with a couple of trustees earlier today, found myself having to take a step back and remind myself while I was reviewing the public comment, not to get defensive about the proposal that we put forward in response to the comments, because the truth of the matter is none of us like it. I don't like it, Audrey doesn't like it, Amy doesn't like it, none of you like it. None of us want to increase these fees. None of us want to provide any limitations on the options for where somebody can sit for the bar exam. We're not putting forth these proposals just because. Rather, we find ourselves in a very difficult budget situation. The 2023 budget for the Office of Admissions projects $17.5 million in revenue and $24.5 million in expenses. That's a $7 million deficit. At the end of 2023, admissions is projected to have $4 million in reserve. In other words, we cannot survive 2024 without some increased revenue, some combination of increases in revenue and decreases in our expenditures. We need to find some of these options, as distasteful as some of them may be, in order to be able to continue to provide the services that we do. So with that, Audrey, if you will take us into the first slide. So I'm going to start and talk about the fee proposals to give us some context for the cost reduction models. And then Audrey and Amy are going to be talking about the cost reduction models for the exam itself. So as the board recalls, we previously presented two options to you for your consideration. One was the break-even approach, where the revenue would cover the expenditures. This approach was strongly supported by the Committee of Bar Examiners, and we brought that information to you. The second option, which was called option 2, the fees were lower for students and non-attorneys, generally limiting the increases on student or non-attorney fees to about 10% in most instances. Unfortunately, that option left us with a resulting $4.5 million deficit in admissions. Next slide. So as a result, guided by the financial realities and your fiduciary responsibilities, the board directed us to come up with a different approach. One that was pretty close to the break-even approach. You were strongly pushing toward that option 1, but understanding that there should be some minor exceptions, and you directed staff to develop another approach and bring that back to you that would get us closer to break-even, but would limit some of the more extreme increases that were included in that first option. So following that direction, staff developed that approach, which moved us significantly closer to break-even. It still leaves us, so we'll talk about this in a little bit, it still leaves us with about a $1 million deficit, so much better than the $4.5 million from option 2, or the current $7 million deficit that we are facing. Next slide. And unless you are standing right up next to the screen, you're not going to be able to see that. The next slide, this represents the current proposal. This slide was, there are actually 3 slides that include what the fee increases are. These were included in what we submitted, what we put out for a further public comment. We'll talk about the public comment in a minute. This includes for reference what the prior option 1 and option 2 were, and indicates what the new proposed fee increases would be. Many of them are what was included in option 1, but changes are to the student application to sit for the bar exam. We went slightly lower than the break-even option, and also for the bar exam, the cost to change your test center also slightly lower than option 1. The other ones that went lower than option 1 by a significant amount, the first-year law students exam, and then by much lesser amounts, the fees related to the moral character application. On the next slide, you'll see the fees that were related to the multi-jurisdictional practice programs, registered in-house counsel, registered military spouse attorney, registered legal aid attorney. We originally only circulated one option for this. There was no distinction between option 1 and option 2, consistent with the theory that we had been using for all of our fees, which are people who are already attorneys in other states likely had a greater ability to absorb cost increases than students and non-attorneys. Because there was no distinction between option 1 and option 2, we didn't make any changes here for what we circulated for public comment. The next slide, Audrey, is the fees related to the law schools. And you'll see we did make some changes here with regard to the fees that are charged to the unaccredited law schools, but we did not make changes to the fees that were proposed in option 1 for the California accredited law schools. You'll recall that there was some discussion at the last meeting because the raw number increase looks so significant for that annual report that they submit. You'll see the current fee is $2,000. The what was originally circulated is option 1, and what we are proposing now is raising that over $20,000 to $22,000. One of the things that we looked at was what's the impact? Because as the CALs told us, the California Accredited Law Schools told us, these costs are likely going to be passed on to students. And so we wanted to know what that meant. And we took a look at what is the impact per student, assuming the schools had to pass the cost on to their entire student body. So looking at each school, what their current tuition and fees are, looking at what their current enrollment numbers are, and we did a calculation, and then we did an average across the CALs. We did the same for the unaccredited law schools, and you'll see those numbers in the slide. So for the California accredited law schools, that $20,000 increase in the annual report averages out to about $225 per student if annually, if that had to be passed on entirely to the student. That was one of the ways that we looked at those numbers to see, is that $22,000, is that $20,000 change in that fee exorbitant if you look at it from that perspective. One of the things that because right now we're not asking the board to take action. I'm giving you context here for the next item, but also an opportunity to give me suggestions for when I do bring this part of it back. The fees will come back to you in September. And one of the things that I wanted to point out that was suggested in a comment from the California Accredited Law Schools is that if we must, right, obviously they disagree with the proposed fee increase, but basically said if we must increase the fee that amount, then we could think about tiering the CALs the same way we do for the unaccredited law schools, where there's a different rate based on the size of the student population. And that's something, if the board would like, I can run those numbers and bring those back in September that shows an approach that would be tiered. The reason to do that is, if there's a school, so as I said, the average per student impact was $224. If there's a school with I don't remember the exact numbers, but there was a fairly small school, and for them the impact is $446 per student. For another school, it's $76 per student. And so the feeling was that the smaller schools and their students would be more heavily impacted by this, and so we could create that tiered structure. I'm not aware of a reason. I'm not aware of any good reasons that would suggest that we shouldn't consider that option, and so I wanted to present that to you all. Next slide. So as I said, with these combination of fee increases on law study and the exams, on the multi-jurisdictional practice and the law school regulation, our projected expenditures would still exceed our projected revenue by just over $1 million. And I'm showing here on the slide where these estimates came from. We were looking and coming up with these numbers at our actual counts, at counts of takers, exam takers, and numbers of multi-jurisdictional practice registered attorneys based on actual 22 counts for 2022, and the projected expenditures were based on the 2023 budget as adjusted to eliminate any one-time costs that were in 2023, and also to restore any one-time cuts that we took in that 2023 budget. So, so this leaves us with $1 million. As a result, I'm sorry, next slide, I'm jumping ahead. So we went out for public comment with this revised approach. Public comment has been open for 2 weeks. There's 2 more weeks left on the public comment period. We've received comments from 185 unique commenters. And I just wanted to sort of for context let you know that in addition to those that we would normally send a request for public comment out to who've signed up on our website to get notice of those kinds of things, we sent communications to roughly 17,000 others in the admissions database to send them notice of the public comment opportunity because we did want to make sure that people who are going to be sitting for the bar exam were aware of this of these proposals. What we circulated is what I had showed you, which is the chart that was referencing the 2 previous options that we considered and the direction that we received from the board and asked them to comment on the revised proposal. So of the 185 commenters, about just under 60% identified themselves as non-attorney bar applicants. We had about just under 20% who were currently attorneys, either attorneys licensed in other states who are going to be sitting for a California exam, members of our multidisciplinary practice program. We had a very, very, very small number of California licensees who also commented. We gave them the opportunity to comment on any of the 3 sets of fee increases, the ones for law study and exams, the increases for special admissions fees, and the increases for law school fees. Some people gave the same comment for all 3. And so since the comments overlapped, I'll just identify for you some of the key themes. First of all, as would be expected, there wasn't a lot of overwhelming support for the fee increases. Comments included things such as the discussion of the fact that the cost of a law school education are currently too high. The students have to pay for bar preparation courses. Their law school costs have gone up. The bar should not be increasing our fees. There were comments that talked about a significant number of comments talked about the significant financial impact on people with disabilities, on lower income individuals, on people of color. We had comments on the fact that these increases would create barriers for aspiring lawyers from disadvantaged backgrounds and underrepresented communities. And by increasing the financial burden, that it may be running directly counter to our efforts to promote diversity and inclusion in the profession. We had folks who talked about the fact that the combination of all of the fees really created a major barrier to entry. There was a theme from the attorney population talking about the difference between the proposed fee to sit for the bar exam for attorneys versus non-attorneys, and they found that differential was unreasonable, especially, as they pointed out, with attorneys taking just a 1-day exam. The comments, just to give you a flavor, used words like unconscionable, unreasonable, unfair, absolutely ridiculous, alarming, and such. and then there were some comments that specifically talked about the law school fees and talked about the tiering those fees and how those fees would increase cost to students on top of all of the other fees. Next slide. So with that, we now have this $1 million deficit that we still have, as sort of moving as many of those comments are. And the board was very clear the last time that we presented this item about the need to cover our costs or come close to covering our costs. And so what we have for you next is a preliminary discussion of some cost reduction models for the bar exam. We're seeking your feedback now. We are trying to, the plan is that we'll be scheduling a special meeting of the board in August. And so this is an opportunity for us to highlight the proposals, to get your initial feedback, to find out if there's additional information that you think would benefit you in being able to make a decision in early August that we can go back over the next couple of weeks and get for you. And so with that, I'm going to turn it over I think I'm turning it over to Audrey.
I'm actually going to be Amy for this slide.
Thank you. Good afternoon, trustees. I'll start with describing the factors that were considered when developing these models. So first of all, the bar exam, as you've heard, is the single largest expenditure in the Office of Admissions. The biggest cost drivers for the bar exam are proctors and facilities. Facility costs have increased, especially post-pandemic. We've also experienced a decline in revenue resulting from a decline in the number of examinees over the past few years. The state bar has successfully executed multiple remotely administered bar exams, as well as has been successful at phasing back into a full in-person exam administration. And so these events have sufficiently prepared state bar staff to explore and offer the most efficient exam delivery method. Throughout our cost reduction exploration, we have not lost sight of the impact of modality changes on applicants with testing accommodations. The state bar remains sensitive to the needs of all of our testing population. And the last point I want to highlight here is that the board may recall that at the conclusion of each of our 3 remote exams, we surveyed examinees about their test taking experience. And at the end of all of the 3 administrations, applicants report a preference for remote testing versus in person. As a matter of fact, examinees who sat for the in-person exam and have been surveyed about their exam experience also report the same preference for a remote exam when they're provided that option. Next slide, please. To better understand the implications of the proposed changes, it's important to know how the bar exam is administered today. It's administered in person at testing locations around the state. In February, we typically provide the exam at 10 to 12 locations around the state. And in July, we provide the exam at 14 to 16 locations around the state. In February 2023, we used 10 locations. For the upcoming exam, we are testing at 15 locations, as we did in July 2022. In-person examinees also receive the questions in hard copy. And with that hard copy, they can elect to either type the answers into a laptop or handwrite the exam. On average, 95% of applicants use a laptop to take the exam, and which leaves us a 5% population that handwrites the exam. Next slide. The exam is administered over 2 days for general applicants. Day 1 consists of the writing portion, or the California portion, sometimes gets referred to that way, 5 essay questions and a performance test. And they're split into 2 sessions, as you can see here. In the morning, you have 3 60-minute essays, and in the afternoon, you have 2 60-minute essays and a 90-minute performance test. Day 2 consists of the multiple choice exam. There are 2 sessions, each containing 100 items. One thing to note here that's important for this exercise is that attorneys who've been practicing in another jurisdiction for at least 4 years do not have to sit for the MBE, the multi-state bar examination. And so as a result, the number of applicants reduces on day 2 of the exam. So typically in February, we experience a 10% reduction. We have on average 10% of attorney applicants take the exam in February. And in July, it's 5%. So the drop is less. We lose 5% of our testing population on day 2 during a July bar exam. Also, it's important to note that the exam schedules vary. Applicants with extended time test longer than 2 days. For example, testing accommodation applicants who have 1.5 times more to take the exam tend to test 3 days rather than 2 tests. And so depending on the accommodation, applicants can test anywhere, applicants with extra time can test anywhere between 3 and up to 6 days. Next slide, please. So the key changes that we're presenting lie in 3 areas: consolidating to fewer sites, delivering the California portion of the exam in remote, and using the state bar offices for testing accommodation applicants. So here are some of the assumptions that have been built into the model. As for the number of applicants, we're forecasting based on trends. And we have been seeing a decline in the number of examinees. So our model assumes 10,600 bar exam applicants in 2024. We're assuming that all of the testing population, approximately 510, will be testing accommodation applicants. We're also seeing increases in the cost of facilities and proctors, and the projections include a 2.3% increase in assumed due to inflation. And the vendor that we're proposing for both the remotely proctored exam and the in-person exam is ExamSoft. As you may be aware, we've continued to use ExamSoft after the remote exams. This vendor provides a software that secures applicant laptops for the in-person exam. That is, the laptops that are used during a bar exam and in-person exam cannot access the website or any internet. And also, it safely delivers an applicant's completed responses back to our office. For the remote exam, ExamSoft provides a software that establishes an applicant's identity. It securely delivers the exam questions to the applicant. It monitors and records the applicant throughout the examination, and then securely delivers exam responses and applicant footage to the State Bar office. Next slide, please. So now onto the models. These cost reduction models were presented at the CBE for their input at their June 23rd meeting. So here, the as-is model refers to carrying out the exam the way we do today. All the components are in person. For the February exam, we're at 10 to 12 sites. For the July exam, we're at 14 to 16 sites. And these require a high volume of proctors to help administer that exam remotely. The annual cost for this model is $5.6 million. Now, for the next 3 models, the cost reduction strategy is to target the largest exam drivers, specifically facilities and proctors. So the first model that you see there is the one we're referring to as the 6 sites. So here, the idea is to identify very large facilities that could seat a large number of applicants, and that can possibly also seat both TA and standard applicants. So here, the proposed sites in this model include the Cow Palace in Daly City, Ontario Convention Center, and the Los Angeles Convention Center. As an example, the Cow Palace could seat 2,600 applicants and can also include space for testing accommodation applicants. Now, with these large sites, it eliminates sites in other areas. So it eliminates the standard TA and TA sites in Oakland, Sacramento, and San Diego. This change, and I didn't mention the 3 TA sites are in Hilton Arden West, Hilton Culver City, and Doubletree Orange. This change yields a savings of $855,000 annually. The next model is the 6-day with 1 remote day model. And so the idea is, in this model, we propose to test on the California portion via remote. So the essays and PT would be tested remotely, and the MBE we're required to do that in person. So as you may recall, the multiple choice section of this exam is developed and regulated by the National Conference of Bar Examiners, and they do not allow any jurisdiction to administer the MBE remotely. We did so in October 2020 and in 2021, and those were exceptions due to the pandemic. So in this model, we would administer the MBE in person as required by the NCBE, and then we would test in remotely for our other components. We would use the six sites proposed in the previous model that I noted there, the 6 sites, with the exception that we would only need it for 1 day. This would lead to about $1.5 million in savings for calendar year 2024. Again, this model would still eliminate test sites in San Diego and a standard test site in Sacramento and also in Oakland. Which means Northern California applicants would test in the Bay Area and San Diego applicants would have to travel north. While the model yields higher cost savings, we have to consider another factor. The model would require reorganizing the exam days. Given that one day of exam is scheduled to occur in person and another remotely, we need to allow sufficient time for applicants to travel, whether to the test center or back home, in order to be able to conform with both modalities. So that needs to be factored in. So the last model here is the 4 sites and 1 remote day, and eliminates 2 of the TA sites and proposes to use the State Bar offices. So in lieu of the 2 TA sites, we would use the San Francisco and the Los Angeles State Bar offices for testing accommodations applicants. This model would increase the annual savings from $1.5 to $1.8 million compared to the as-is model. At their June meeting, the CBE voted and recommended the 6 sites models with the 1-day remote. So the third model that I explained earlier. And since that meeting, the State Bar have explored other issues requiring us to propose other considerations that you'll hear about in a moment.
Okay, it's my turn. Hello, everyone. So you might be asking yourself, how did we think about these sites and how to reduce the numbers of sites that we are going to use? And so obviously we're very thoughtful about a reduction of geographical areas. And like Donna started us with, no one wants to do this. And I know it wouldn't have been anyone's choice. But we were looking at different things. So which venues were available in 2024 with enough seating capacity to have those economy of scale kind of conversations where we can have some TA rooms along with standard applicant rooms. So as Amy was talking about, we have eliminated in our geographical selection to have a site in San Diego, and instead we are looking at Ontario Convention Center, which we have used for many years. And Ontario is a site where we can also take up space for testing accommodation applicants. San Diego, we are always historically challenged to find good testing space. July especially is challenging. You might know this, but July, there's a very large comic convention happening in July that takes up a lot of the available hotel and convention space in San Diego, such that in July we use Town and Country Resort for our space, which, as you can imagine, is not the best price point. Looking at the Bay Area, the Cow Palace is right outside of San Francisco on the San Francisco Daly City border. Why we might have chosen that over Sacramento? Well, Sacramento is one of the areas where we use the fewest seats in February or July, so it doesn't have the highest uptake in the Bay Area. And the Safe Credit Union, where we have been testing will no longer sign our addendum. So we have an addendum that guarantees that the venue will have the required insurance, will ensure that we have the right testing environment for noise, et cetera. And the venue said they won't sign that addendum anymore. So we were already on the hunt for different space in Sacramento. Again, we can look at this, the Cow Palace space in Daly City right outside of San Francisco. They not only have the required number of standard testing seats that we would need to combine what we're losing from Oakland and Sacramento, but they also have rooms available for accommodated applicants. Again, looking at cost, Ontario is cheaper than sites in San Diego, and Cow Palace, the site I'm talking about right outside of San Francisco, it has a very good price point as well. We did look at community colleges, we looked at law schools. Issues there are, between February and July, there may not be available space at some of those schools because they are using them for class. Looking at basketball arenas or different areas that might be a very large space by square footage, but you might have to cover the entire floor. You'd have to put in tables and get power run to every seat. And then that just makes the cost more and more, and actually the usable testing space less and less. So we have been looking at non-traditional testing space, and our better luck are things that are not hotels, but that are more still more event space or convention space. Next slide to myself. So when we looked at these cost models, we were looking at the California portion, the written portion. How can we go remote with that option? And we still would like to explore that. But there are a lot of questions about how to administer the one part of the exam remotely. So how can we increase the kinds of accommodations that can be administered remotely? What can we learn in some critical conversations with those in the disability community? What can we learn from everyone's lessons, all the other jurisdictions, as well as our own lessons learned from the pandemic? How can we kind of increase the amount of applicants who need accommodations but can be accommodated remotely? And we need to think through those questions. What is the impact of psychometrically of taking the exam over, maybe 2 weeks? So day 1 and day 2, which we traditionally have one after another, taking them instead over multiple weeks. And then the vendor. So we talked about ExamSoft. We've been using ExamSoft for a long time, and we use them in a different way during the pandemic. But can we get enough assurances that if we use them for the proctoring aspect, the web camera proctoring aspect, that we won't have technical glitches and we'll have enough support? Okay, so we talked about this already. What we had initially recommended was maybe if we could go, the cheapest option might have been to go remote. We talked about this at the CBE meeting, but we are now looking at the option, because there's so many emerging questions, for February 2024 to go all in person, but to use the reduced number of sites. So we were looking initially at the 4 contracted sites, the large super sites, and then state bar offices. These are where we tested this past February. I don't need to read this aloud to you, and this is what we're looking at for next February if we were going to use the state bar offices. So considerations with our own offices is how we might be able to transform the cubicles and the private offices for high stakes testing. We are selling our building in San Francisco, so there's going to be new ownership. What kinds of capacity, what kinds of restrictions might be there? There's going to be renovations, changes, a reduction in footprint for our own floors. And then we don't know yet. There's a lot of unknowns for the dates in February and the dates of July about what exactly will be happening in the state bar offices. So we've revised our thinking there because the San Francisco State Bar Office, again, has a lot of unknowns. So again, looking to contract with more sites and only to use the State Bar Office in LA. So if we look at that last column there on the far right, we're not going to realize as much as we might have if we use the State Bar Office for this in-person testing in February, but we'd still realize an overall cost savings of around $340,000 when we reduce the number of sites overall and we use the LA office. Donna, actually, I think you were going to talk about this slide.
Yeah, and that number obviously was for February only. As Amy and Audrey indicated, we are looking to do more potentially in July if we are able to tackle the questions we have about doing this remotely. But if this were the only savings, the $340,000, if this were the only savings that we were to realize all year, then we still have a $700,000 deficit that we would need to address for admissions. And there are a couple of ways that we could address that. One would be a general fund loan. The other, as most trustees know, there was language that was put into the fee bill, SB 40, that would specifically give us flexibility to expend sale proceeds on costs of exam administration. And so that would be an option as well. Again, we don't actually expect that the only changes we'd make are for February. If we did, in fact, even if we just continued for February, continued in July, what we're proposing for February, we would get significantly closer to the $1 million. But by making a decision for February only, it will give us a slightly longer time horizon to identify a longer-term solution.
So other challenges that we're thinking about, thinking through as we look to change the exam for next year, the longer we wait to actually secure contracts with these facilities, then we might lose space, right? If they have someone who will give them money for our dates, they will go with the person who gives them the money first. So if we lose space, that's going to, disrupt some of this planning. How do we take our existing model? So we have all these existing staffing models. Our staff are all trained and ready to go next week to administer the bar exam, right? So we have this existing staffing model that works with space that is not, 2,600 examinees testing at the same time. So how do we kind of create a new staffing model? How do we source enough proctors for one venue that might be close to 3,000 testers, right? So these are things we need to think through. And then how do we coordinate, once we can get those contracts in order, how do we coordinate all the rest of the dependencies and deliverables for February on such a tight timeline? Because February is going to be here before we know it. I'm not sure that we need to go through all this recap, actually, because I know it's late. I think you understand what we've been talking about overall and what the recommendations are for, but please ask me any questions if you want us to go through. What we're looking toward now is this last column on the right, which is not using the San Francisco office because of all the unknowns, contracting with another hotel to do those accommodated applicants. Most likely in Burlingame, because that is a very high usage area in the Bay Area for accommodated applicants already, and then having that cost savings now of around $340,000.
You can skip that slide, go to the next one. And so also this proposal is also out for public comment, has also been out for 2 weeks, has another 2 weeks on the public comment period. We received 159. We received comments from 159 unique commenters. It was sent to the same universe of 17,000 people. We shared with the commenters the various models that were considered by the Committee of Bar Examiners. Ultimately, what we asked for, because you've now seen our evolution of thinking on this, what we asked for them to comment on was our first staff version of the recommendation, which is the 6 in-person sites, 2 of which would be the state bar offices, right? As Audrey told you, that's not our current staff recommendation. It's now the 6 sites, but only 1 of those would be our offices. And we did indicate in the request for public comment what our goal was, to move toward a place where we could go with 1 day remote and 1 day in person. We had about 30% or so of the commenters agreed if modified with the proposal, and 65% or so disagreed. I wouldn't really sort of read too much into that. I think that's a higher percentage of agree than really actually agreed if you look at the comments. General themes, again,
these would not surprise you. That it would add significant burden and stress to those living outside of the areas where the sites will be located. On top of the fee increases proposed, this is an additional financial impact that makes it especially burdensome. There were concerns expressed by some with reference to some of the specific sites that we were proposing to eliminate. So 12 people specifically referenced the elimination of San Diego, 18 people the elimination of Sacramento, and 11 the elimination of Oakland. There was a lot of support for adopting a remote option. Many of the commenters actually talked about going fully remote. However, until we stop using the NCBE's multiple choice question, that's not an option that's open to us right now. There were alternatively some comments that did express concern with or opposition to a remote testing. There were comments about the large size of the test centers, maybe creating more distractions, anxiety, or stress for the test takers if you're in a room of 2,600 as opposed to a room of 800. There were comments that noted the additional difficulty of having to travel further and stay overnight for those with certain disabilities. And then there were finally, another theme was those commenters who talked about eliminating the bar exam or other suggestions that were not within the scope of what we're talking about today. And so with that, we would be interested in getting your feedback on these proposals as we're thinking about them. As I mentioned specifically, if you would like any particular information that will help you make a decision at our August meeting when it comes to the cost reduction models, we would love to hear that so we can produce any additional data that you would need. And then once we decide the cost reduction model, ultimately that may impact the proposal we come back to you finally within September with the fees. But certainly would want your input at this point on the direction that we've been moving in with the fees.
Thank you, Ms. Hershkovitz, Ms. Ching, Ms. Nunez. Clearly, this is a lot of work on some very, very difficult questions without any readily apparent answers, easy or not. So I thank you for your diligence. I see Trustee Knoll's hand has gone up. Greg, I think you're still on mute.
I'm interested, thank you. I'm interested in a very small portion of this. How long has this deficit been allowed to go on? How many years? Can somebody answer that?
I don't have that figure in front of me. I know we've at a couple of past board meetings, we've talked more in depth about the condition of the admissions fund and what it looks like. Certainly, it is something that we have had a deficit for a number of years, and there are quite a number of reasons that attribute to that. Also, we've had some additional costs in the last couple of years, which have made it more difficult to be able to sustain. But importantly, we haven't had any fee increases, and this is why I started the discussion with that context setting. We haven't had any fee increases on most of these fee items since at least 2016. Some it was before 2014. At the same time, we have had hotel expenses that go up. We've increased the rate for proctors. There's increased labor costs. Everything costs more now than it did in 2010. And so those increases in the face of no increases in the fees, which are the only way we can support our services and our programs, necessarily is going to ultimately lead to this situation. But it certainly has been at least a few years that we've been operating at a deficit.
85% generally of a nonprofit's budget is the personnel. And as a result of this issue, have there been any reductions in personnel as a result to try to meet some of this problem?
We have been we've been subjecting ourselves to the same hiring freezes that we have for general funded positions in the Office of Admissions, but we have not eliminated positions. And frankly, we receive criticism for the amount of time it takes us to process things already. And so if we were to reduce the staffing levels, the service level is would not be, we wouldn't be able to maintain that, the existing service levels.
Thank you.
Donna, is it fair to say that the 50% vacancy rate that we've been talking about in other contexts is what you're talking about here?
15?
15, yeah, 15.
So yeah, so we have been trying to sort of meet the vacancy, the vacancy rate, and doing so by keeping positions open for 90 days after they become vacant. I don't know what the current vacancy rate in the office is, but I know we've been although generally those restrictions have been discussed in the terms of the general fund, because the admissions fund is in such dire circumstances. We have also been applying those general rules into that fund.
Thank you. Trustee Buenaventura, please.
Yes, so just in giving you some kind of direction as to what I'd like to maybe you explore. And I'm not wedded to any of these ideas, but I'm just, it's popping through my head. So it seems like a lot of the expenses are the proctoring issue. And I'd like to know more about the breakdown of the proctoring costs. What advances in technology can you explore? I know a big thing now is the use of AI and what is out there in terms of what that seems to be producing, which is being more efficient and being able to get some of these things done. So I'd like to see what can be done in terms of advancing more technology to solve some of the proctoring issues. The other thing that you had mentioned is that the MBE is an issue because that can't be done remotely. I'd like to find out why it can't be done remotely, if there are other ways to get it done remotely. And then also, so I know there has been a debate about eliminating the MBE entirely. Some people think that that's not a good measure of what a lawyer is going to be. Memorizing law that they'll never use when they practice may not be the best indicator. So I'd like some data or some information as to, and also like from other states, is it the MBE, is it, have they eliminated that? What's the reasoning behind it? And because it seems like a lot of this also has, a lot of what we're trying to do is reduce the expenses, and maybe that's another issue.
I think you mentioned a lot of things that I might try to answer really quickly. So the MBE, the multiple choice section of the exam, that content is owned by the National Conference of Bar Examiners. We purchase it to use as part of our exam to help scale our exam. So they control whether or not it's administered in person or remotely. And they, since post-pandemic, they have not allowed anything but in-person administration of that portion. However, the NCBE is developing a whole new test, the next gen bar exam, that is not going to have that same kind of multiple choice content. And it might have some multiple choice in it, but not in the same way. So we're already on the path not to be using the content anymore, because there's going to be a new exam launched by them. And the recommendations that came out of our Blue Ribbon Commission are to have a California developed exam So we'll see where that recommendation goes. And in that case, if we have a California developed exam, we might be able to administer the entire exam remotely at some point. And to your first point, the remote proctoring does already use AI. So when you do the webcam recording proctoring, the first level of review that happens with that is an AI level of review that will generate a number of flags that then a person does review. So it is already built into those kinds of proctoring systems. I think I hit most of what you were talking about, but we're not quite there yet with what you were asking about, but I think that is that's going to be the roadmap.
Okay, thank you.
Thank you, Ray. Thank you, Audrey. Trustee Trejo, please.
I'd like to make one point, and I certainly appreciate the painstaking process that it's taken, and it's clear that these are very difficult decisions that you're going through. I think that if I were running my business with an operational deficit, I wouldn't have my business very much longer. And certainly, there's two kind of key components in managing that, right? That's your costs, which we're already going through and trying to figure out without really affecting the quality of service that you ultimately want to provide and get the results that you need. But then the other one, especially in the light of no fee increases over a long period of time, is that you have to increase your revenue. So although I appreciate the painstaking process taken, I think that it's important to speak of these deficits and to try to begin to deal with them and to solve them in their entirities. I understand that you're sensitive, and I appreciate these kind of piecemeal solutions, but I think that the idea of having to raise rates here has become abundantly clear to me just from a purely operational standpoint. Now, degree is what we're talking about, but I appreciate you delivering this news because it's important to talk about and have it out in the open. We have a fiduciary duty to be able to speak about these things. So for that, I'm grateful. But I think that those are the balances. I think that I just want to make that comment. I think that if we're not a business, agreed, but there are certain principles that are essential to be able to be functioning as an entity.
Yes, and that's exactly why we've been considering both of these things, is increasing the fees in order to get the revenue up, and then proposing these changes to how we administer the bar exam to get some of those, the biggest cost drivers down, so we could come to a balanced budget. What we've presented to you today, obviously, is something that gets us close, but doesn't quite get us there. If we, went back with, option one on the fee increases, that would get us to that break-even point.
Trustee Tony, please.
Thank you. I have several comments. The first is something that I'm just going to express profound disappointment that we're still using ExamSoft after long discussions about their incompetence, about their, breach of contract, and I would like that to be on a September agenda. So enough said about ExamSoft. I have complained about them at every meeting since I was appointed. Two, I'd like to know more about the proposed reduction in fees for the application for legal aid attorney and the application for military spouse attorney. A 21% reduction seems to be an outlier in the amidst the sea of increases that are being proposed. My third point is, it is true that these fees have not been raised since 2016, or in some cases before 2014. I want to say we should be very clear as an institution, the difference between the licensee fee, in which the authority lies with the state legislature, and the admissions fees and the other fees we talked about at the last meeting, whose authority rests with the state bar. I'm glad, I think it has been a very serious oversight that the state bar has let these fees be, not be reviewed for so many years, and I hope this is a lesson learned for all of us, that you don't wait 6 or 7 years to review fees of which we have control. And I think us doing this puts us in a better position to ask the legislature for an increase. I think it's very easy for them to say, well, if you're not even increasing the fees that you have control over, maybe it's not that high of a priority for you, as you say. So I think this is a good thing that we're doing this. And I will say that I like the prior option number 1 as opposed to these proposed new fees. That's just me. That's where I'm going. I think whatever we end up adopting, we should also adopt a regular review. My opinion is every 2 years. I know there's some, budgetary issues, but I would, 2 to 3 years at the very latest, with an inflation adjustment in between the years that we don't review it. That would be my recommendation. The one piece of information I'd be curious about is knowing, and it doesn't have to be, it can be a sample, in California, what the tuition increase percentages were from 2016 to 2023. I don't know that information. I tried to Google it. I couldn't find it, but if we could get a little bit of that, I want context. Those are my comments.
If I could just add on to that, I'm sorry, Donna, but I would just like to differentiate between the accredited law schools and the non-accredited law schools on the tuition increases, if we get that data, sure.
Yeah, absolutely. We collect the fees and tuition as part of our annual report, and we will we'll absolutely bring that back to you. In response to your prior question, Mr. Tony.
Donna, it just in considering the time, if Trustee Tony is okay, I would like to just gather the questions, and then when we come back, we'll come back with the answers.
I'm perfectly okay not to have any more responses. Thank you.
As long as we're talking about the accredited law schools, I'm personally in favor of getting the data on the tiering, so that, so that's just sort of truer numbers for our consideration in August. Anybody else?
Have we gathered data from other states and whether they charge similar fees, and if so, what those fees are? And I guess I would relate to law school accreditation and then also administration of exams. So any of the, excuse me, the similarly situated states.
We can bring all the jurisdiction information about the exams. Most other states don't have nearly the structure we have of the law schools, but I think we can look at we can show you the ABA, what the ABA charges.
Thank you. Anyone else? Trustee Sowell.
Since we're just gathering questions, I appreciate the comments about public facilities, but I was wondering whether or not we've looked at DGS facilities or that are under control of DGS. I was been in a couple state buildings here recently where there's literally nobody in them right now, and so that was one thing. Have we ever administered more than 2 exams in a year? And I don't know if that pencils or not, but I just had a thought about, even though we don't go to maybe as many sites each time, maybe you rotate certain sites or certain areas that weren't captured in maybe when the exam was administered previously. And then my last question was, are there folks that are subject to the fee structure that might have to pay multiple fees for various sort of exams? And I was just wondering whether or not, and I don't know if this pencils or not, if there's any sort of cost benefit related to this, but whether or not you could do some bundling, and so you got to take 3 exams, and maybe there's a little bit of a different rate that you get because you have to take 3 exams or something like that. It may not pencil, but just a thought.
Trustee Buenaventura.
Donna, I wanted to address what you said when you used the term barriers to entry. I I think that's a really good principle to keep in mind, because fees that will be barriers to entry is something that I'm gonna be really skeptical about. But maybe this is my ignorance, but once you pass the bar, what are the fees, if any, after that? In other words, that don't sort of qualify for barriers to entry. And I'd like to get some kind of accounting of how much a typical law student, if you will pay up until the point where they take the bar. And then after they pass the bar, are there any fees or any other things that they have to pay after that? I just would like some kind of budget to see what they're going to be facing.
Do you mean beyond the annual licensing fee that you're
Correct.
aware of? Okay.
Yes.
Trustee Sewell again.
I know we're trying to get out of here, but Mark, your question about tuition, that was just law school tuition, correct? You know, I would add on to that, Donna, I would add on, what has the state done in terms of UC CSUs in terms of tuition increases? Because I think it would be a very, very sort of interesting comparison, because I know that those costs have gone up very significantly. And so that would give us something comparative as it relates to the fee increases that we might be talking about.
It's a throwback to my student government days. The UC Regents, at least, were very clear. Those were not tuition, that is fees. Anyone else? Thank you for hanging in there, everyone. This has been a long but productive day. Actually, not that long of a day if you think about it. We started 3 hours later than we normally do, but it is late in the day, so we're going to adjourn for we're going to recess for the evening and reconvene open session tomorrow morning at 9 a.m. Thank you all for your hard work. We'll see you tomorrow.